A federal judge in Iowa temporarily blocked a state law banning books with sexual content from school libraries, saying there was no evidence that such books cause widespread problems and applying a palette of orthodoxy. The law is incredibly broad, requiring hundreds of to be removed from school libraries, including nonfiction history books, classic works of fiction, Pulitzer Prize-winning contemporary novels, books regularly featured on advanced placement exams, and even designed to help students avoid being victimized by sexual assault, she said. Judge Stephen Lochner wrote in his decision to approve the preliminary injunction. The sweeping restrictions in Senate Brief 496 are unlikely to meet the First Amendment under any standard of review and therefore may not be enforced while the case is pending. Indeed, the court could not find a single case even remotely close to Senate Brief 496 that maintained the constitutionality of a school library restriction. Kim Reynolds signed the sweeping legislation in May. It also includes broad restrictions on teaching LGBTQ issues in schools, some of which Lochner also put on hold for being laughably vague. The law prohibits programs, promotion, and instruction regarding gender identity and sexual orientation to students in these grades. Although these terms are defined in a neutral way that makes no distinction between cisgender, transgender identity or homosexual straight relationships, judge wrote, meaning on its face, the law recognizes any program, promotion, instruction that anyone is male or female is in any type of relationship. The statute is therefore independent terms of content, but not so wildly extremely excessively extreme it is so overloaded that every district and elementary school teacher in state has been violation since the day year began. He said statute was so vague that violated due process clause of 14th Amendment Constitution. Because state would have vague discretion decide when enforce it and against whom, making impossible for a reasonable person determine what would lead punishment, and know what will let it. It did not stop a provision requiring school districts to notify parents if child requests use of different pronouns, but only because plaintiff students in case were already out to their families and therefore not tangibly affected by this requirement. Reynolds, a Republican, said he was extremely disappointed in the decision. Gender identity and sexual orientation instruction has no place in kindergarten through 6th grade classrooms and as clearly defined in the Iowa Code. There should be no question that books containing sexually explicit content do not belong in a school library for children. The language is so broad that school districts and educators are on the side removing the book out of fear being penalized for not being able to do it, Lochner said. More than 500 books were removed from a single school, and some teachers are H.